Hello everyone. The topics we will discuss today. These topics are from the Indian Partnership Act of 1932. And the topics are registration of partnership firm, procedure of registration of partnership firm, and consequences of non-registration of partnership firm. Okay, these are getting covered under the Indian Partnership Act of 1932. Okay, the Indian Partnership Act of 1932. So the first point we will discuss is registration of partnership. Registration of partnership. Now, as per the Partnership Act of 1932, it is not compulsory to register a partnership firm. The firm does not have a separate legal identity, and the registration, it will not alter or change this particular fact. However, registration is the definite proof of the existence of the firm and also its legality. So we can say partnership firm, as we know, cannot be regarded as an artificial personality, and as such it is not having a separate legal entity. By registration, the partnership firm cannot gain the advantages of artificial personality like the corporations, the companies have. But then also the registration, it becomes vital, or we can say substantial, when it comes to test the authenticity of a partnership firm, and also especially when it comes to determine the rights and liabilities of the partners towards each other and also towards the third parties. The registration of the partnership firm, it plays a vital role in this regard. Okay. Now, non-registration of a firm has, if I can put it in this way, it has some real life legal consequences for the partners and the firm itself. So it is always advisable to draw up a written partnership deed and register the partnership firm with the Registrar of Firms, Registrar. So you may ask this question, who is an registrar? Registrar, registrar. So registrar is an official who is responsible for keeping a register, register, or official records, we can say. Now let us now discuss about the consequences of not doing registration, or consequences of non-registration. So the partnership firm cannot file legal proceedings. This is the first point we will discuss. The firm cannot file legal proceedings against any third party for any situation. Like, for example, if the client, who is a third party, has not paid his dues to the firm, to the partnership firm, the firm cannot sue him if it is unregistered. If the client or the third party has not paid his or her dues to the firm, to the partnership firm, the partnership firm cannot sue him if it is unregistered, if the partnership firm is unregistered. Now suppose, let me make it clear, suppose let's say T is the third party. And let's say A, B, C, D, E, F, they are the partners. Suppose the partnership firm, it has not been registered. T, the third party, let's say, did one financial transaction with the partnership firm and was, let's say, supposed to give 10 lakh rupees. But later on, suppose T, the third party, rejected to pay the amount to the partnership firm. Now here, if the partnership firm is, let's say, non-registered, then it will be very difficult to recover the money from the third party in this regard, okay, in this situation. The second point is an unregistered firm cannot file a case against a partner for any reason, like for example for mismanagement, for theft, etc. Okay, now to make it clear, let's say A, B, C, D, E, F, the same old story. They formed a partnership firm, but it was not registered. Later on, D, who is one of the partners of the partnership firm, let's say, misappropriated certain amount of money from the partnership firm. Now, if the partnership firm, if it is not registered, what will happen? Other partners here cannot take actions against D, who is also one of the partners under the Indian Partnership Act. Okay, so a partner of an unregistered firm cannot file a suit against one of the other partners either. I am repeating this again. A partner of an unregistered firm cannot file a suit against one of the other partners either. Now let us discuss about procedure of registration. Now, according to the Indian Partnership Act of 1932, there is no limit as such for the registration of a firm. The firm can be registered on the date when it is incorporated or any such date after so. The requisite fees and fines, it must be paid. And now let us discuss about the more about the procedure for such a registration of partnership firm. The first point is application to the Registrar of Firms in the prescribed form. Nowadays, this facility is even available online. Okay, such an application must contain certain basic details about the firm, like for example, name of the partnership firm. It should contain name of the partnership firm, name and address of all partners, place of business, that is address of main and also that of the branch offices, what will be the duration of the partnership, date of joining of the partners, date of commencement of the business of the partnership firm, and so on. Okay, this is the first point, application to the Registrar of Firms in the prescribed form. The second point is the duly signed copy of the partnership deed. The duly signed copy of the partnership deed, which contains all the terms and conditions. Okay, the partnership deed. It must be filled with the registrar. Okay, the partnership deed, which contains all the terms and conditions of the partnership firm, must be filled with the registrar. Now, all the partners are required. All the partners, we can say, are required to put their signature on the partnership deed or the partnership agreement, which is the presence of partners during the registration of the partnership firm, it is necessary. It is important. Not only presence, but they have to put their signatures also on the partnership deed or in the partnership agreement. And that also in front of the registrar. In front of the registrar, they have to put their signature on the partnership deed in front of the registrar. When the signing will be completed, they will be regarded as what? As partners individually, and collectively they will be known as a partnership firm. Now, while forming the partnership firm, they have to give the name of the partnership firm, and the partnership deed will contain all the terms and conditions which are related to the partnership firm, and all the partners should unanimously by giving free and mutual consent should agree to the terms and conditions of the partnership deed. Okay, of the partnership deed. So this was the second point. That is, the second point is all about the duly signed copy of the partnership deed must be filled with the registrar. So this was point number 2. Now let us come to the third point here. Deposit, pay the necessary fees and stamp duties. I am repeating this again. The third point, deposit, pay the necessary fees and stamp duties. So, for the registration of a partnership firm, the necessary amount should be paid, including the stamp duties will be applicable as per the existing law of the land. Now, you may ask, what is stamp duty? STAMP DUTY, stamp duty. Now, the stamp duty is a state levy or tax or charge which is paid to register a document, typically an agreement or transaction paper between two or more parties with the registrar, or in front of the registrar. Usually it is a fixed amount, we can say, depending on the nature of document, or is charged at a certain percentage of the agreement value stated in the document. Okay. So the third point is all about deposit, pay the necessary fees and stamp duties. So for the registration of partnership firm, the necessary amount should be paid, including the stamp duties will be applicable as per the existing law of the land. Now, the fourth point here. Once the registrar approves the application, the firm will be entered into the records. And the registrar will also issue a certificate of incorporation. Let me make it clear. When, after seeing all the necessary steps completed for the establishment of the partnership firm, after seeing all this, the registrar will give approval for the incorporation, or we can say or beginning of the partnership firm. The registrar then will record the name of the partnership firm and other details related to the partnership firm, like number of partners, terms and conditions of the partnership firm, the objective behind creating the partnership firm, that is the subject matter, the business which the partnership firm will carry on, etc. All these things will be recorded, and ultimately the partnership firm will get what? Will get legal recognition. Okay. And this is how the process of registration will be completed, and the firm will attain legal recognition ultimately. Okay. So the question that we may ask is that, so the question now which can be vitally asked here, what a partnership deed is all about. What is partnership deed? Okay, what is a partnership deed, and what a partnership deed must contain? So I am repeating the question again. So the question now which can be vitally asked is that, what a partnership deed is all about. At the same time, what a partnership deed must contain. Okay. So these are the two questions here. Now, partnership is the result of an agreement. There is no doubt regarding this, that partnership is what? It is the result of an agreement. No particular formalities are required for an agreement of partnership. It may be in writing, or it may be formed verbally, orally. Okay, but it is always desirable to have the partnership agreement in writing to avoid future disputes. The document in writing containing the various terms and conditions as to the relationship of the partners to each other is called the partnership deed. Okay, is called the partnership deed. Now it should be drafted, that is the partnership deed, it must be drafted with care and be stamped according to the provision of the Stamp Act of 1899. Stamp Act of 1899, where the partnership comprises immovable property. The instrument of partnership must be in writing, stamped and registered under the Registration Act. Okay. So partnership deed may contain these vital points. Okay, these vital things it must contain. Partnership deed may contain the following information that we will discuss now. Number one, it must contain name of the partnership firm. That is the partnership deed. It must contain the name of the partnership firm, and then name of all the partners. Then the third point is nature and place of the business of the firm, nature and place of the business of the firm. Then fourth point is date of commencement of partnership, duration of the partnership firm, capital contribution of each partner, profit sharing ratio of the partners, admission and retirement of a partner. So it must contain all these things, and also like for example rates of interest on capital, drawings and loans, provisions for settlement of accounts in the case of dissolution of the partnership firm, like provisions for salaries or commissions payable to the partners, if any, provisions for expulsion of a partner in case of gross breach of duty or let's say of fraud. All these things the partnership deed must contain. Okay, the partnership deed must contain all these things. Now let us discuss about consequences of non-registration of firm, consequences of non-registration of partnership firm. While the English law makes registration of firms compulsory and levies a fine for non-registration, the Indian Partnership Act of 1932, it has no such compulsions for firm registration and no fines for non-registration either. However, under section 69 of the Indian Partnership Act of 1932, certain disabilities are imposed on non-registered firms. These disabilities have, we can say, a persuasive pressure on firms, on partnership firms for registration. Now let us discuss these aspects in detail. Now we are discussing consequences of non-registration of firm, and section 69 of the Indian Partnership Act of 1932, it offers a detailed explanation of the consequences of not opting for firm registration. These are number one, the first point that we will discuss. No suit in a civil court by the firm or other co-partners against any third party. I am repeating the first point again. No suit in a civil court by the firm or other co-partners against any third party. So if the firm registration it is not done, let's say, then the firm or any other person on its behalf cannot file a suit against a third party for breach of contract which the firm has entered into, the partnership firm has entered into. Further, the person filing the suit on behalf of the firm should be in the register of the or record of the firm as a partner. Okay. Now let me make it clear here by citing one example. Suppose, let's say a partnership firm, it was formed by A, B, C, D, E, F. So they are the partners, okay? They formed the partnership firm. And the firm did one, let's say, financial transaction with T, the third party. T here is the third party, let's say, okay, in this example. Suppose T, the third party, was responsible to pay 10 lakh rupees. But later on, T, the third party, let's say, rejected to pay the sum to the partnership firm and created breach of contract. Suppose one of the partners, let's say F, one of the partners went to the civil court for the remedy and tried to file a suit against T, the third party, in the name of the partnership firm. Here, F cannot file this case in the name of partnership firm if the partnership firm is not registered. If the partnership firm is registered, then the suit can be filed in the civil court against T, the third party, for relief. But let's say the partnership firm is not registered. It also means what? Not only the suit cannot be filed in the name of the partnership firm, at the same time the person who went to file the civil case for the breach of contract will also be treated as a non-partner. because partners in the registered partnership firm have legally recorded registered names. But here is the partnership firm itself is not registered. We can say the names of the persons involved will be considered as non-partners. So though Indian Partnership Act 1932 is not giving any explicit compulsion or force for the registration of partnership firm, but this registration is not only necessary, but the necessities which are there to compel to register the name of the partnership firm. Okay, these necessities are there to compel to register the name of the partnership firm. Okay, so this is what the first point is all about. That is, no suit in a civil court by the firm or other co-partners against any third party. Okay. Now let us come to the second point here. No relief to partners for set off of claim. Okay. No relief to partners for set off of claim. So I will explain it. I will make it easy. Now, without firm registration, without the registration of the partnership firm, any action brought against the firm by a third party having a value of more than 100 rupees cannot be set off by the firm or any of its partners. Pursuance of other proceedings to enforce rights arising from the contract cannot be done either. Let me make it clear. Now, what is set off? Set off, it means a right to seek reduction or reduction or discharge of a debt or claim by countering a party's claim with an independent claim. I am repeating this again. Set off, it means a right to seek reduction or discharge of a debt or claim by countering a party's claim with an independent claim. So we can say it's a counter claim which is made by the defendant. Let's say the defendant here is the partnership firm. Here the partnership firm, being the defendant, made a counter claim against the plaintiff. Let's say the plaintiff here is a third party. The plaintiff here is a third party, okay, the client of the partnership firm. Now the counter claim has been made by the defendant, that is the partnership firm. Against whom? Against the third party, who is the plaintiff. For reduction or discharge of a debt by the reason of an independent debt, let's say, arising out of another transaction. So here, if the partnership firm is not registered, let's say, the counter claim cannot be made by the defendant partnership firm if the amount of counter claim it exceeds rupees 100. By claiming a set off, the defendant does not necessarily deny the plaintiff's original demand. This is very important. By claiming a set off, the defendant does not necessarily deny the plaintiff's original demand, but the defendant claims the right to prove that the plaintiff owes the defendant amount of money from other transaction, and that the amount should be deducted from the plaintiff's claim. Let me make it more clear. Like if the plaintiff third party demands, let's say, 1 lakh rupees because of a transaction, the defendant partnership firm may show another transaction which happened with the plaintiff. Suppose the amount of another transaction, it was, let's say, 50,000 rupees. So if the civil court believes this counterclaim is valid, made by the defendant will pay only 50,000 rupees out of 1 lakh claim by the plaintiff. If the defendant partnership firm is registered, then only it can be claimed. So let's say a partnership firm has not been registered, and the same partnership firm entered into a transaction with let's say T, the third party. So if T, the third party, thinks that the partnership firm has done breach of contract with him. And for that, T, the third party, let's say, filed a suit in a civil court claiming 1 lakh rupees from the partnership firm. Now, we have to understand the partnership is not registered here in this example. Suppose there was another transaction which was done between the partnership firm and T, the third party, and the partnership firm did what? Did counterclaim by saying by saying the firm will return the money, no doubt, to T, the third party. But there was another transaction which happened between the partnership firm with that of T, the third party. So the second claim made by the partnership firm is what? Is independent counterclaim. And we know, as the partnership firm is not registered, and as it is not registered, no further counterclaim can be made by the partnership firm in its name. The amount here of the counterclaim, let's say, is 50,000 rupees. So it is also exceeding 100 rupees. It is also exceeding 50,000 rupees. So it is also exceeding what? 100 rupees. So as the partnership firm is not registered, this counterclaim cannot be made by the partnership firm, because ultimately, due to non-registration, it will not be treated as a partnership firm. Okay, it is simple. Now let us come to the third point here. An aggrieved partner cannot bring legal action against other partner or the firm. I am repeating this again, the third point. An aggrieved partner cannot bring legal action against other partner or the partnership firm. Okay. Now, a partner of the firm or any person on his behalf cannot bring legal action against the partnership firm or against any partner or alleged to be a partner if firm registration is not done. However, if the firm is dissolved, then such a person can sue the firm for dissolution. It accounts and realization of his share in the firm's property. Now let me make it clear. Suppose, let's say A, B, C, D, E, F. They planned to open one partnership firm, but suppose they did not register the partnership firm. They did not register the partnership firm. Let's say one of the partners, F, invested money in the partnership firm on request from another partner, let's say B. And later on, F discovered that B took the money for his personal purpose, and it was not taken for the firm activities or the activities of the firm. It was not taken for that. So here F has become what? The F here in this example has become the aggrieved party. And as the partnership firm is not registered, F cannot bring legal suit against B or the entire partnership firm here. Though individually applying other laws of the land, B can be made liable. Like, for example, Section 420 of the Indian Penal Code of 1860, it can be applied in this regard, and other laws can also be made applicable against B. But let's say the firm is getting dissolved. Here the aggrieved party in this regard can sue the partnership firm to claim his share in the firm's property, in the property of the partnership firm. Now let us come to the fourth point here. The fourth point. A third party can sue the firm. A third party can sue the firm. See, even if the firm registration is not done, a third party can bring legal action against the firm. Now let's say the partnership firm, it was formed with a, let's say, with a fraudulent intention to take money from the third parties, from the clients. As the firm has been created in this example with a fraudulent intention, it has not been intentionally registered. Here the non-registration of the partnership firm will not give the partnership firm, the non-registered partnership firm, the immunity to the partners, to the persons involved with the firm from getting sued by the third parties. Here the non-registration of the partnership firm will not give immunity to the persons involved with the firm from getting sued by the third parties. Even if the firm is not registered, the third parties can sue. Now it is also important. It is also important to note that despite these disabilities, the non-registration of a firm does not affect, number one, the right of a third party to sue the firm or any partner. I'm repeating this again. It is also important to note that despite these disabilities, the non-registration of a firm does not affect, number one, the right of a third party to sue the firm or any partner. Number two, partners' right to sue the firm for dissolution or settlement of accounts in case of dissolution. Like, let's say, if the non-registered partnership firm is dissolved, the partner's right to sue the firm for dissolution or settlement of accounts, like how much money or other properties that partner invested in the firm, all these things can be claimed during dissolution of the partnership firm. Like, for example, if a partner invested, let's say, money for the partnership firm, but that partner had no idea that the partnership firm was created with a fraudulent intention to take money only. When the partnership firm will get dissolved, this non-registered partnership firm will get dissolved, the aggrieved partner will get the right to claim his own share or the invested properties, even if the partnership firm is not registered. Even if the partnership firm is not registered, okay? Now, let us discuss about the third point, okay, which is coming under this this particular point, that is, it is also important to note that despite these disabilities, the non-registration of a firm does not affect. So we have discussed the first point. The first point was the right of a third party to sue the firm or any partner. The second point was what? Partner's right to sue the firm for dissolution or settlement of accounts in case of dissolution. The third point here is that the power of the official assignees. The power of the official assignees, receiver of court, to release the property of the insolvent partner and bring an action. I'm repeating this third point again. The power of the official assignees, receiver of court, to release the property of the insolvent partner and bring an action. Now, how to simplify this? Okay, let me simplify it. Let's say a non-registered partnership firm, let's say it has become insolvent, that further that partnership firm cannot be continued due to insolvency. Now, as the whole partnership firm here got insolvent, the official assignees, the receivers of court, they will be appointed as per the existing laws of the land, and they will be responsible for what? To release the property of the insolvent partnership firm or that of the insolvent partners to the third parties, who will have the right to claim their shares in the partnership firm, even if the firm is a non-registered partnership firm. Okay. Now, the fourth point under this thing that we will discuss now is the right of the firm and partners to sue or claim set off if the value of the suit does not exceed rupees 100. I am repeating this again. The right of the firm and partners to sue or claim set off if the value of the suit does not exceed rupees 100. Now, if the firm, let's say, is non-registered partnership firm or not registered, if the amount is rupees 100 or below, it can be claimed. It can be claimed as what? As counterclaim from the third parties. It can be done even if the partnership firm is not registered. Even if the partnership firm is not registered. Now, let's say if the firm is non-registered and the counterclaim by the partnership firm from the plaintiff, it exceeds rupees 100. Here it cannot be done. Such type of counterclaim cannot be claimed by the non-registered partnership firm. So what we have discussed is that, I am repeating this again, it is also important to note that despite these disabilities that we have discussed, the non-registration of a firm does not affect, number one, the right of a third party to sue the firm or any partner. Number two, partner's right to sue the firm for dissolution or settlement of accounts in case of dissolution. Number three, the power of the official assignees, receiver of court, to release the property of the insolvent partner and bring an action. Number four, the right of the firm and partners to sue or claim set off if the value of the suit does not exceed rupees 100. Okay. Now let us discuss more about effect of non-registration. So section 69 of the Indian Partnership Act of 1932, it contains a nugatory principle, as it states that no action will lie against the partners or even against a third person if the firm in question is not registered or non-registered. The court of law is bound to observe the mandate of the said section, that is section 69, and no amount of contract or agreement between the partners can change the principle contemplated in this particular in the said section, that is section 69 of the Indian Partnership Act. So it is clear that registration of firm, of the partnership firm, it is necessary, but it is also necessary that all the partners at the time of filing the suit must be or have been mentioned as partners in the Register of Firms, that we have discussed. Okay, and the provisions contained in section 69 of the Act, of the Indian Partnership Act, are mandatory, and it further makes it clear that the rights of a partner, whether vested or acquired by him, will be void if the firm, if it is not registered. Okay. Now you may ask this question: registration of firm, why it is, when it is not necessary? Registration of firm when it is not necessary. Now in certain matters the registration of firm is not necessary, where number one, the suit for claim or set off does not exceed rupees 100, that we have already discussed now, and number two, the suit is instituted for accounting or for dissolution of firm, that we have also discussed. And another thing is that what are the essential ingredients of section 69? The essential ingredients of section 69. So to apply section 69 of the Indian Partnership Act of 1932, the following elements are necessary that we will discuss now. Number one, the firm is registered, and number two, the persons suing are or have been shown in the Register of Firms as partners in the firm, recorded as the partners in the firm. Notably, non-fulfillment of either of the conditions is fatal to suit. Okay. Now, the Bombay High Court in Gandhi and Company versus Krishna Glass Private Limited. I am repeating the name of the case. The Bombay High Court in Gandhi and Company versus Krishna Glass Private Limited, 1993 case, has held that the suit filed by a partnership firm must fail if the name of one of the partners has not been shown in the Register of Firms on the date of filing the suit. I am repeating this again. The Bombay High Court in Gandhi and Company versus Krishna Glass Private Limited, 1993 case, has held that the suit filed by a partnership firm must fail if the name of one of the partners has not been shown in the Register of Firms on the date of filing of the suit. Now, Gandhi and Company versus Krishna Glass Private Limited. So we can say the names of all the partners, it should be there in the Register of Firms, because partnership is all about what? Partnership is all about starting a joint venture, and each and every partner must be registered. If, let's say, let me cite one example: A, B, C, D, E, F, they started a partnership firm. Suppose if F, one of the partners, is not registered by is not registered, but let's say other partners are registered partners, it will amount to more or less non-registration of partnership firm, and to take civil actions by the partnership firm will become legally invalid, as one of the partners did not register. Okay. The next case is Shriram Finance Corporation versus Yashin Khan. In Shriram Finance Corporation versus Yashin Khan, 1989 case, wherein the suit was filed by a registered firm, but there was a change in its composition, whereas two of the partners shown in the Register of Firms retired. One new partner was included, rather added, and minors admitted to the benefit of the partnership firm. The suit was filed by the firm in question after change in the composition, but before change was notified to the Registrar of Firms. It was held by the Supreme Court of India that the suit was not maintainable, as the current partners on the date of suit were not shown in the Register of Firms. I am repeating this case again, okay? In Shriram Finance Corporation versus Yashin Khan, 1989 case, wherein the suit was filed by a registered firm, but there was a change in its composition, whereas two of the partners shown in the Registrar of Firms retired. One new partner was included, rather added, and minors admitted to the benefit of the partnership firm. The suit was filed by the firm in question after change in the composition, but before change was notified to the Registrar of Firms. It was held by the Supreme Court that the suit was not maintainable, as the current partners on the date of suit were not shown in the Register of Firms. Now we can say, in this case, Shriram Finance Corporation versus Yashin Khan, 1989 case, Supreme Court judgment, where there will be any change in the composition of the partnership firm, it must be communicated and notified to the Registrar of Firms. Otherwise, it may amount to non-registration of the partnership firm. Okay, thank you.